340B drug pricing webinar. We really appreciate everyone being here. My name is Richard Church. I am in the RTP and Chicago offices of K&L Gates and co-lead our healthcare practice along with specializing in 340B program matters. For those of you that are new to K&L, and I think a lot of clients out there, but for those that are new to K&L, it's a global law firm of more than 2,000 lawyers, 44 offices in 5 continents, and counsel industries across the globe in all of their needs. Specific to healthcare, our healthcare practice is one of the largest in the US and nationally ranked. And we've been very, very fortunate, as many are aware, to open a Nashville office just earlier this year, which adds to and expands our overall healthcare practice. Throughout our practice, we have worked for many, many years in the 340B program, and you see many of the 340B experts on this call who we'll introduce in a moment. We're also exceptionally pleased to have Tom Merga with us. Tom is the editor-in-chief of the 340B report, which many of you, I'm sure, subscribe to, and in a special bonus at the end of this presentation, we'll have a link that you can go to subscribe at a discounted rate to the 340B report that Tom has provided. Tom, as an accomplished journalist, more than 40 years in journalism and specifically in the DC area, covering a variety of policy issues. He started his career at Education Week. He then moved on to the New Democrat, and after that, ultimately then moved on to 340B Health, what was Safety Net Hospitals at the time that many of you are familiar with, before joining Ted Schlafsky at 340B Report. So he's going to be our moderator today, a super insider on 340B, and help put the questions to us that we hope we'll cover. At the end of the session, we will have time for question and answer that Tom will be moderating. So feel free to tee up questions in the chat, as was outlined in that earlier slide. With that, let me quickly introduce the other K&L Gates folks on the line. Andy Ruskin is resident in our Washington, D.C. office, and Andy represents both covered entities and manufacturers in 340B matters. Leah Richardson is in our Research Triangle Park office, a partner there, and specializes as well in the 340B program, as well as grantee compliance matters that are important for grantees that are also participants in the 340B program. And finally, Victoria Hamsho is a lawyer in our Washington, D.C. office with Andy. Victoria is a multi-tool player. She toggles between both the policy and the regulatory side, and had a prior career with K&L Gates, also following the 340B program on the Hill, and has attended many a 340B hearing and litigation matter there in DC. So with that, I'm going to turn it over to Tom to get us started.
Oh, thanks, Rich. And to all of the people who are joining us today, for those of you who are either subscribers to or sponsors of 340B Report, thank you very much. You are our lifeblood, and without you, there would be no 340B Report. So again, thank you very much. Rich, where we're going to start with contract pharmacy. And this is one instance where I am very thankful to be asking the questions and not having to answer the questions. There are, by my count, 8 manufacturers so far that have announced restrictions on or conditions on provision of 340B pricing when covered entities use contract pharmacies. 6 lawsuits by manufacturers against the federal government, challenging the federal government's May findings that the manufacturers are in violation of the 340B statute. 2 lawsuits by grantee covered entity organizations revolving around the 340B Administrative Dispute Resolution Program. 2 lawsuits by pharma, one related to the ADR process another just filed within the last few days, challenging an Arkansas state law, and a lawsuit also recently filed by a manufacturer, technology vendor, Calderos, the aim of which is to get a declaration that what the manufacturers are doing is by the book and kosher. Tell us what the manufacturers are doing, why they're doing it, how HHS and HRSA have responded, and what the practical effects on covered entities, manufacturers' bottom lines, and third parties like Calderos, like 340B ESP, like the third party administrators. It's a lot to chew on. Take it away.
Yeah, I mean, this again, this has been a remarkable, year or a little bit more now that we've been tracking this issue. And really, what you're seeing at a macro level is the confluence of multiple things, all kind of hitting now together, resulting in these actions. So I think one of the baselines is you have to go back to multiple attacks on HRSA's authority, and its ability to do sub-regulatory guidance or even regulations in many instances. So go back to the orphan drug litigation, go back to a grantee having a very, very successful federal court action to get audit findings thrown out. And you really had an ability for manufacturers, I think, to see that HRSA didn't have authority in certain areas that maybe it had regulated. In that regard, it's important to note that contract pharmacy is not explicitly in the words of the 340B statute. So this was something that HRSA developed very early in the program with the single contract pharmacy model to meet a very specific need. Grantees like federal qualified health centers said, this is a great program, but we don't have a pharmacy, so we have no way to access this for our patients. Obviously, then the confluence of new events is that HRSA then expanded that guidance to allow multiple contract pharmacy locations. And as larger entities began participating and using that program, it has grown dramatically. And so there's a lot of contract pharmacies now in a way that were not in existence even 10 years ago. And manufacturers obviously have a view that maybe that is not intended, or at least not within the scope of what HRSA's authority was. The other thing you had is a kind of a separate line of action from manufacturers who were essentially saying, we're willing to allow this to continue, but we're very concerned about duplicate discounts. But now with an expanded view of what is a duplicate discount, not just a Medicaid duplicate discount or a Medicaid managed care duplicate discount, but any discount given to a 340B entity when they were otherwise paying a rebate to a manufacturer, to a PBM. And so they wanted data. So I think there's one set of manufacturers that, and again, really pulling this from the cases themselves. One set is concerned about the scope and the expansion of contract pharmacy. One set's saying, hey, if we just get the data to prevent duplicate discounts, we'll allow it to continue, but we don't want to allow it to continue with if there are duplicate discounts.
What does your gut tell you about where the courts are leaning on contract pharmacy and its legality?
Yeah, it's a great question, Tom. And I think it's a very real possibility that we'll see different courts go different ways. And because as you pointed out, you've got a very fascinating situation just as a lawyer and a litigator where multiple cases are progressing simultaneously. They've not all been consolidated. They're all on slightly different timelines. So, we certainly have some early indications in a couple of these cases that seems to suggest a lot of questions being asked by the judges that are handling those cases about HRSA's authority, and certainly, would suggest maybe they're leaning in a negative direction on contract pharmacy. But whether you'll see an across-the-board sweep, I think, is also really unlikely. So you may well have a need then for these cases to progress up to some higher level court that begins to reconcile, what is often referred to as a circuit split or even a circuit court split in this case, would be amazingly complicated. Let's say you actually had a different rule in one state than another state based on how district courts ruled in the short term, all of which could happen.
There's one case, the pharma case in Baltimore, filed in Baltimore, that is directly a challenge to the constitutionality and legality of the 340B ADR final rule. How do you, and in at least a couple of the cases, Lilly, Sanofi, and I know there's one more, but I can't think, where 340B ADR claims are raised. How do you think that's going? What's your gut telling you how that's going to go?
Yeah, again, interesting question and distinguishable from the contract pharmacy fact pattern because ADR is something that probably HRSA has authority to issue would be my view, just given the drafting of the law. I think a lot of that challenge is more the way the ADR rule was actually promulgated and obviously happened quite quickly at the end of the last administration. So my expectation, at the end of the day there is you may see more deference, but you'll have to really see how that plays out. It's also a lot more likely there that the government just goes back and does the work again and fixes it and re-puts ADR in place.
One final question, because pretty soon we're going to have to move on to the next section. Also, very, very recently, pharma filed a suit in the Eastern District of Arkansas challenging a one-of-a-kind state law that, in effect, forbids drug manufacturers from engaging in the type of conditions and restrictions on contract pharmacy that you're seeing at issue in these 6 lawsuits right now. Could you tell us a little bit about that lawsuit and where it is probably headed?
Yeah, this is a really interesting one, and we'll talk about Rutledge a little bit later. And Arkansas clearly is on the forefront and wants to be the state pushing the boundaries on these issues. So essentially, yeah, it's a fascinating law. This basically, I would summarize it as Arkansas saying, essentially, we think you have to comply with the federal 340B statute on contract pharmacy when you're operating in Arkansas. So the first thing that went through the Department of Insurance, and there was a process to challenge that with the Department of Insurance, and they asked for a stay and got a temporary stay, which is in place through the Department of Insurance. But simultaneously, while that Department of Insurance process was running, then pharma brought a lawsuit in district court in Arkansas, which probably will make a ruling on this. It's a really fascinating argument because essentially pharma is saying, hey, Arkansas shouldn't be allowed to enforce its law until a district court somewhere else in the country makes a decision about whether this is proper to have contract pharmacy. Now, the flip side of that argument, if you're a covered entity, is you're saying, wait, there's no, because they're essentially saying there's a potential conflict between Arkansas law and federal law. But the covered entities, of course, are saying, but wait, right now, HHS agrees with us and HRSA agrees with us, PA agrees with us. So there's no conflict here between federal law and Arkansas law because HHS says federal law requires contract pharmacies. Arkansas law says federal law requires contract pharmacies. So it will be really interesting to see what that judge does in Arkansas, because I think you could sort of spin that either way. Clearly, both parties have, and that's what we'll wait to see.
Leah, this is, I think, a really great segue into your segment of the webinar. As Rich mentioned, Arkansas, for whatever reason, seems to have very much been at the forefront of both 340B contract pharmacy and the broader issue of, or the related issue of payer and PBM reimbursement for 340B purchased drugs. Do you want to tell us a little bit more about not just this specific new Arkansas law, but the predecessor law that led to the Supreme Court ruling in Rutledge?
Yeah, so in 2015, Arkansas passed an Act 900 that did a lot of things, but essentially the important thing here is that it prohibited PBMs from reimbursing pharmacies at less than their actual acquisition cost. And it gave the pharmacies appeal rights and the option to not fill the script if they were going to lose money on it. And pharma, sued the state for non-enforcement of that law. So at the district court, Pharma won. So their argument was that it was preempted by both Medicare Part D regulations and also ERISA, because it was in their mind was having an effect on ERISA benefit plans and Part D plans and how those plans administer their benefits. So the district court agreed that the law was preempted by ERISA, but not Part D. So both sides appealed. And then the Eighth Circuit held that the statute was preempted by both ERISA and Part D. So then Arkansas appealed to the Supreme Court, and they only appealed on the ERISA preemption issue. So the Supreme Court never got to the Part D issue, but the Supreme Court held that that particular statute was not preempted by ERISA, and that Arkansas is permitted to regulate PBM reimbursement in that way. So, there's still the outstanding issue of whether a statute like that would be preempted by Medicare Part D regulations. And, it's not completely on point to the issue that 340B entities are struggling with, which is the two-tier reimbursement that we're starting to see from PBM. So it's we won the war, or won the battle, but not the war.
Why, speaking of two-tiered reimbursement, why are states, not the federal government, leading the charge on this?
Well, I think states are leading the charge because the federal government has not led the charge, although there's proposed legislation that we can talk about in a minute. So HRSA has taken the position that, two-tier reimbursement from PBMs, which means that in a participating provider agreement, if there's a 340B purchase drug, that's going to be reimbursed differently to the pharmacy or to the covered entity than the same drug that was not purchased at the 340B price. So HRSA has taken the position that they don't have the authority to regulate that practice, and that there's nothing in the 340B statute that prohibits that practice. And so it's essentially just a business term that the parties need to work out. And again, there's no other kind of similar federal prohibition on that practice. And so states have been kind of taking, the issue into their own hands.
There was, now we're talking about mainly the 2015 law. Can you talk a little bit about the state law that was passed with respect, well, it was broader than contract pharmacy, and I think that was one of the interesting aspects of it and little remarked aspects of that law. Could you tell us a little bit about, I think it's called Act 1103, the new Arkansas law that prohibits prohibits manufacturers from
yeah, the statute that Rich was just referring to.
Yes. Yeah.
Very simple. It's a big statute, but it's the part that pharma is having issue with is
Right.
very small and narrow, and it basically just says that pharma PBMs have to reimburse contract pharmacies that are contracted to dispense 340B drugs on behalf of covered entities in a similar way that they do other pharmacies, and they can't exclude them from the network. So while there's a lot of states now pushing for or have passed or are in the progress of passing these kind of statutes to prohibit two-tier reimbursement in some way. A lot of times they're focused on 340B, the 340B entity themselves, although often they include the contract pharmacy. This Arkansas statute specifically zeroes in on the pharmacies themselves. So it's meant to protect the Arkansas community pharmacies.
You referenced earlier federal legislation that would address two-tier pricing. Could you tell us a little bit more about that?
Yeah, so in August, there was both a Republican and a Democrat congressman and woman put forth what's called the Protect 340B Act of 2021. So it is the federal, version of what these states are trying to do. So it amends the Public Health Service Act, which is where the 340B statute is located. And it prohibits insurers and PBMs from discriminating against both 340B entities and their contract pharmacies on the basis of their status as a 340B participant in imposing different reimbursement or rules under contract. So, it specifically prohibits, reimbursement differences, fee differences, participation in standard and preferred networks based on 340B status, interfering with patient choice, et cetera. So it's a comprehensive kind of, bit of legislation.
What do you think is going to happen with that bill?
Well, that's a good question. I mean, it's hard to say. I think that the folks in Washington are very, focused on the Build Back Better Act. And, and so there's, I think it's going to be hard to garner a lot of attention and support for this while that's going on. But that said, I mean, with the ongoing litigation that Rich has talked about and the struggles with the 340B program internally, I think it will, hopefully it will get some attention once the infrastructure bill is finalized.
If there's still time toward the end of the event, I'd like to come back to you with some questions about what's going on with the states, but this seems to be a natural segue again into part 3 of the webinar, and that's other federal legislation. And Victoria and Leah just mentioned the Build Back Better Act. Could you tell us a little? Tell us a little bit about what's going on Capitol Hill with respect to legislation to do something about prescription drug prices via the Build Back Better Act. And how and what's in play or what's potentially in play that might impact 340B.
Thank you, Tom, and thank you, Leah. I think it'd be helpful just by way of background, as folks probably remember, last spring, President Biden released what he deemed to be the 2 components of his Build Back Better agenda. And so one component was the American Jobs Plan, which outlined his physical infrastructure priorities. And this is everything from transportation, clean drinking water, housing, schools, workplace development, and some of the tax proposals that we hear about. The second component is what is referred to as American Families Plan. And that focused on what he labeled his human infrastructure priorities. And this included healthcare, as well as anything from paid leave, childcare, education, retirement, tax, and other areas. And so what we've seen over the past month is we've had congressional Democrats working to advance legislation implementing both of these components. Over the summer, the Senate passed the Infrastructure Investment and Jobs Act, which called for $500 billion in new spending for traditional physical infrastructure priorities. And so this bill is pending in the House. And more importantly for our purposes, the House also approved a $3.5 trillion fiscal year 2022 budget resolution. And this budget resolution set up all the drafting and the consideration of what is now being referred to in the media as a reconciliation package that aims to carry all of President Biden's or some of his major priorities in human infrastructure. And so over the past month, all of these House committees have been drafting and marking up the respective portions of the package. On the healthcare side, more broadly, you see from the media, there's a proposal to expand Medicare benefits to cover some dental, vision, and hearing care. There's a proposal to expand and make permanent the enhanced ACA premium tax credit provisions from the American Rescue Plan Act, address the Medicaid gap, fund CHIP, as well as other provisions. But I think for our purposes, a lot of these big healthcare proposals are designed to be paid for in part by drug pricing provisions. And so we see that there was an effort in the House committees to try to include as a pay for HR 3, which passed the House in 2019, but was not taken out by the Senate. And that would allow Medicare to negotiate drug pricing with manufacturers. And this is a proposal that was included as part of President Biden's Build Back Better agenda when he first took office. And it's also something that has been included and reinforced more recently in the Department of Health and Human Services Comprehensive Plan for Addressing Drug Prices, which implement President Biden's executive order on competition in the economy. And I will say that I think right now, in terms of what would impact 340B stakeholders, the scope of all these provisions is still under negotiation. And indeed, I would say drug pricing has been one of the most controversial aspects of this package. And Tom, you might remember from, when the House Energy and Commerce Committee was marking up the drug pricing provisions of this package. It actually failed to advance it. There was Democratic opposition to some of the drug pricing provisions there, which is important because Democrats can only lose 3 votes and still be able to pass the bill. And so the House Ways and Means Committee advanced a very similar proposal, but it failed in the House Energy and Commerce Committee. So this is something that Democratic leadership is very much keeping an eye out and trying to work with their more moderate counterparts as well as the Senate on. And most recently, with very specifically in 340B, there are concerns that, like I said, this legislation is still being negotiated. And so there are concerns that there might be some 340B proposals that might get attached to this package. I know there was a letter circulated by some of the safety net providers requesting leadership to not include language that could impact 340B savings. At this point, we still don't have the language, so it's unclear what will get or not get included, but it is something that we're continuing to monitor and keep an eye out for our clients and interested parties.
You've been speaking so far mainly about what's been happening on the House side. About a week and a half ago, there were reports that drug pricing language was going to emerge from the Senate Finance Committee, and that was the last we heard about that. What are you hearing?
Definitely, I think, yes. So right now, just because this is a budget reconciliation package, it has to emerge from the House, which is what
Right.
the House took the initiative to start to have all the committees marking up their portions of the bill. So normally, the way it would go, they would mark and pass this package. It would go to the Senate. If there were changes, they would have to go back to the House. And I think right now, my sense is that's what they're trying to avoid. Right now, they're trying to avoid passing a package that would fail in the Senate, which is, and as you've probably seen just from the news, there are big divisions, not only, as I mentioned, with regard to Democratic priorities in the House, but there's also big divisions with their more moderate members in the Senate, particularly Senator Manchin and Senator Sinema. And the concerns span from everything from the actual price tag of the package. Senator Manchin said that he had like a $1.5 trillion like margin for this package, which is, as you can imagine, is very different than 3.5 trillion. And so I think right now, a lot of what's been slowing down this bill is just trying to figure out not only the price tag, and then trying to see how that's going to impact some of the provisions. Drug pricing, as I said, is very important in the healthcare space because it's supposed to pay for a lot of the other healthcare provisions there. So if that doesn't get included, it can impact some of the other provisions there, like the ACA tax credits or the Medicare benefit expansion pieces.
Leah mentioned the Spanberger-McKinley bill that would address two-tier pricing for 340B purchased drugs. There is other legislation, both introduced or proposed, either in amendment form, mainly by both. Bipartisan. There's bipartisan legislation, and then there's principally Republican legislation that would be disfavorable from the covered entity point of view. Could you talk about some of the bills and ideas that are being discussed?
Certainly. And I mean, it's been interesting. I think most recently we saw there's a representative, a first-term representative for Montana, Representative Matt Rosendale. He introduced a bill that would impose new 340B program requirements. And it's a wide-ranging bill. I think that is one example of a 340B bill that faces very long odds of passage. It has not garnered bipartisan support. I don't think it has any co-sponsors as of today, even though it was just introduced a couple of weeks ago. But it also matters, and I think when we're assessing some of these bills, it matters where the representatives introducing the bills sit in committee. This is an example where Representative Rosendale, he's not a member of House Energy and Commerce, which has primary jurisdiction over 340B. And so he would need to find a legislative vehicle for this bill. And as Leah mentioned, I think right now, unless there was a very active effort to attach this to the drug pricing provisions in the reconciliation package, or potentially a year-end funding bill, which tends to carry a lot of healthcare provisions that are must-do items by the end of the year, it's not something that we would expect to be acted on in the near term. But that said, I do think, as Rich mentioned earlier today, there is certainly an interest in making substantive legislative changes to the program. I think the House Energy and Commerce Committee and Senate Health Committee Republican members have been advocating for substantial changes to the program in recent years. And that all stem back from like a 2018 report where they found, as Rich mentioned, that HRSA lacked authority to oversee the program. And they were recommending not only providing HRSA with greater authority, but also enhancing transparency provisions there. And so it's interesting because the Senate Health Committee followed with several hearings, and we just saw just last year, both committees issuing a request for information on ideas to quote, how to improve the 340B program. And so this is something that's very much active and is still playing out in Congress, despite the current priorities on infrastructure and reconciliation. And I think some of the proposals that are of interest include one from Senator Mike Braun he's a Republican from Indiana. He's a member of the Senate Health Committee, and he introduced last year a very wide and comprehensive drug pricing bill called the Fair Care Act. And that included some 340B proposals. This did not move, in part because the focus was on COVID-19 relief, and it was not attached to some of the COVID-19 relief laws that were passing. But it started activity on the 340B front, and we just saw, I believe it was last week or the week before, he introduced the 340B Accountability Act, which would permit the Secretary of Health and Human Services to audit covered entities on how they're using the savings from the program. And so, like I said, with the other example, I think in the immediate term, it's unclear how these bills would move, just given that there's not a lot of legislative days left in the year, and that there's very big priorities that still need to be addressed from the legislative front. But I do think that it's important for our clients and other stakeholders to keep an eye out on these proposals, particularly as we head into next year and we face the 2022 elections. I think that if either the House or the Senate were to flip or both, and Republicans took control of either or both chambers, I think this is a space where we might see a lot more considerable action. And to the extent that both houses flip, we could see a lot more movement on the 340B legislative front.
To be continued. Thank you for that overview. That was very comprehensive, and there's a lot of ground to cover. One other subject that has been of keen interest to 340B hospitals in particular is a CMS regulation that took effect with calendar year 2018 that deeply reduced Medicare Part B reimbursement for for certain hospitals, 340B purchased physician administered drugs. In just a couple of days, CMS is expected to release its final rule. It'll be the treatment of this hospital reimbursement for physician administered 340B purchased drugs is in the context of the hospital outpatient prospective payment system annual rule. Andy, I know that the hospital community expected the Biden administration to reverse itself and not continue those cuts. But when CMS issued its proposed rule in the summer, it said those cuts should continue. Was that a surprise to you?
Yeah, so unfortunately, savings are like crack to a government agency, and so it actually did not come as too much as a surprise. Also, we have to understand this is the administration's first year, and so they're not about to make a lot of dynamic changes this early on. That being said, it would also OMB would have considered it to be an incredible cost because they'd already won. The administration has already won at the D.C. Circuit, and so for the administration to be doing anything dramatic, it essentially would be increasing the public fisc at this point, even if this is to some extent manna from heaven, in that it wasn't money that existed until the policy had been implemented only a couple of years ago. So unfortunately, it's not a surprise given the circumstances. But we'll talk about in a second the Supreme Court, the Supreme Court case, as well as the fact that there's always a chance that something else will happen. Interestingly, however, you didn't hear either Leah or Victoria mention any sort of bill in Congress to try to undo this from through a legislative process, and unfortunately that doesn't seem to be in the works, notwithstanding that everyone thought that would be also an appropriate avenue to try to address this.
Could you tell us a little bit about the AHA and Associated Hospitals Group's lawsuit and its bumpy road to the Supreme Court?
Yeah, so AHA sued CMS, HHS, pretty much immediately after, even before, quite frankly, the rule went into effect. The district court initially had bounced it, saying you don't have a claim here, and so they waited for the law to go into effect. There were claims. The district court actually allowed the plaintiffs, HA, AAMC, and one other trade association, went after the agency once they did have some claims that had been paid in accordance with the revised law. The court said we're going to allow you to be in federal court, notwithstanding that you did not exhaust your administrative rights, because we believe that it would have been moot for you to try, or futile to be able to try to proceed forward given the definitiveness of the agency's actions. The court also sidestepped preclusion of judicial review provisions, which could have also have nixed this. The court basically said, because you all are challenging whether the agency acted within its authority, i.e. whether or not it was acting ultra vires, that it was able to go to federal court, because otherwise there's really no avenue to challenge agency action if it's not acting in accordance with the statute. CMS lost at that level, but then at the appellate court level, the court, the lead judge for the D.C. Circuit applied a very different standard and basically said, unless the statute unambiguously precludes the agency's action, then we will generally be deferential to the agency. Now, that's for those of us who are lawyers. This was a very unusual decision on the part of a court, because as to whether or not the agency has statutory authority to begin with, that's generally not something that you rely on the agency in the first instance to be making a determination of. And so it's because the court didn't wait till what we call the second step of what's known as Chevron deference in the Chevron analysis to figure out if the agency acted wholly arbitrarily and capriciously before deferring to the agency's choice of regulation. This is now in front of the Supreme Court. The Supreme Court is looking at this, and apparently the Supreme Court has a lot of other interested stakeholders that have nothing to do with 340B that are apparently also weighing in and suggesting that the agency should be held to a stricter standard when trying to evaluate whether the agency upheld the statute or not. As to whether or not the agency's choices were the most consistent with the statute, that's a different story. But as to whether or not the agency acted in accordance with the statute within the bounds of the statute, that's fairly in front of the Supreme Court at the particular moment.
This is an unscripted question, but and it's crazy, but I'm going to ask anyway.
Okay.
This is the appeals court ruling came from the Federal Appeals Court for the D.C. Circuit. There are
Correct.
two 340B contract pharmacy lawsuits that have been filed in U.S. District Court for the D.C. Circuit. You referenced a ruling by the D.C. Court of Appeal, or the U.S. Court of Appeals for the D.C. Circuit, that basically, that I wished I'd written this down, that basically said that if I'm paraphrasing you correctly, if the agency, if you could repeat the grounds upon which the agency upheld CMS, it was that
the court, yeah, it's unambiguously precluded. So yes, you are correct if you're about to go to in this direction, Tom, which is that the same covered entities that will benefit from the Supreme Court saying that an agency has to adhere to the plain language of the statute when that plain language is discernible are the same ones that may not benefit so much when they're trying to get contract pharmacy language, which is, as you know, as we all have to acknowledge, the words contract pharmacy do not appear in the Public Health Service Act. And so, yes, the same Supreme Court jurisprudence on this particular issue could actually work to the covered entity's detriment on the back end. But the story's not over there. Just remember that we're talking about whether or not an agency is entitled to deference when you are examining its ability, whether or not it adhered to the plain language. An agency is still entitled, however, to some level of deference at the second stage. So if the statute does not have a plain meaning after using traditional tools of statutory construction, you move to what's called Chevron Step 2, which is, did the agency's action otherwise ring true as being reasonable? And reasonable is a very low bar. And so we will, we're going to have to see. We're already seeing inklings from several courts that there's no plain language with respect to contract pharmacy. And then we're going to get to questions regarding did HRSA otherwise act reasonably when putting forward its contract pharmacy language. But the fact that we're, on the one hand, trying to limit CMS's authority to act in a way that is counter to the plain meaning of the statute is at odds to some extent with some of the cases and are championing what HHS is doing to carry the mantle in other cases. So yes, there is definitely that dichotomy in interest from the perspective of the covered entity.
Do you think the composition, this litigation has been percolating since at least 2017. I think you were right. The suit was filed even before the regulation took effect. Do you think the changed composition of the Supreme Court is going to change? If this suit had been filed a few years ago, do you think it might have been decided differently? Do you think the composition of the court is going to affect how this case is decided?
I think we've seen jurisprudence go in a certain direction. So even before the current composition of the court had been seated, we saw cases like a case called Alina, which is a major case that basically said that CMS cannot act without rulemaking due to the fact that it has a mini APA, so to speak, within the Medicare Act. And so that was before the current composition, which is now even more conservative leaning. I think what you tend to see as you get more, so first of all, I think what we've come to understand, and the Trump administration was a catalyst of this, was that agencies are not always using their expertise. In some cases, they are outcomes driven for policy reasons that do not necessarily tie to the policy reasons that led Congress to enact laws to begin with. So you just see a general, a greater level of skepticism by the courts regarding agency action, and a lot more fine-tuning of an analysis that doesn't simply say agency deference, expert, we're just going to go with what they said. It's not totally ridiculous. You start to see the agency, you start to see courts generally, but we also, typically see with conservative-leaning judges more of a strict constructionist approach, and so we may very well find that this particular group of justices is even more likely to hold an agency to the plain meaning of the statute and suggest to them that if you really wanted this authority, your first step should have been to go back to Congress and ask for it. So, so we may see a confluence of a couple of different factors that come into play that do further curtail agency authority.
We're getting close to the end on this, and I would like to invite everyone who's in the audience to please use the chat function to send us your questions. We've got about 11 minutes remaining, and we'd love to hear from you. Turning back to I'm going to throw this open to everybody. Turning back to contract pharmacy, from the manufacturer perspective, what type of jurist would you like to have in terms of judicial philosophy? What type of jurist would be most beneficial to the outcome that you're seeking? And if you're from the covered entities perspective, even though they're friends of the court, they're not direct litigants, but they do have a stake in the outcome. What type of jurist would be most beneficial for them in hearing these lawsuits? Anybody?
I'll start with the manufacturer perspective, and then Rich can jump in with the covered entity perspective. But yeah, I mean, again, if you are generally skeptical that agencies are always faithfully adhering to the law, so if you generally are skeptical of government and government overreach, then chances are you will perhaps be more willing to rule in favor of a manufacturer in a case like this. But correct me if I'm wrong. I'm not so sure if these are all being challenged on APA grounds. I don't know if we're going to have any jurists who are involved in this. There is a question, I guess, of the ADR process ultimately does make its way to federal court, and I don't know if when those cases go to federal court, if perhaps those cases will be jury trials. But I think the current cases are all challenging agency action on APA grounds, and typically you do not have, the district court even sits as in an appellate capacity in those types of cases. So.
In speaking of the ADR process, it's new to everybody. It's new to every single stakeholder. But you all are familiar with other akin administrative law processes. What should stakeholders, if you were a manufacturer or if you were a covered entity bringing a petition, what should one expect if how might the process unfold? What should stakeholders expect to experience and see from these processes?
Yeah, and I can jump in on that one, Tom. That process, I will say, is a little bit unique in that a couple of key things came along with that rule. One, you essentially have the ability to bring a class action ADR hearing, and particularly for covered entities, that makes the cost of bringing an action associated with one of these, sort of very public, this is just the position, quite a bit lower and a lot simpler. And so that, that was a really significant, and that is quite atypical to how you'd expect alternative dispute resolution to work, which is typically an agreement that two parties reach within a contract that, hey, it's going to be a lot cheaper to resolve this through ADR. And then typically the other thing that Andy just mentioned is there's not normally a direct path to take that to a judge if you don't like the outcome. Whereas here, this is it's a refereeing relationship between two private parties, but interpreting federal rules, and therefore it has this federal, judicial overlay, all of which is very unique and strange, and you would not see in any other. It's typically binding arbitration. It's quite hard, quite frankly, to get a judge to review it. The whole point is I've agreed to binding arbitration, and the outcome is the outcome. So it's probably more noteworthy from a process perspective for how it's this kind of hybrid ADR, like process, but with a very unique federal overlay. And of course, very unusual to have federal officials sitting on your ADR panel. Typically, it's retired judges or other lawyers that practice in the space. So all that looks just really quite unique and odd. So I think that does mean how this progresses will be very interesting. But to Andy's point, this is probably the cleanest path to being able to say, I have a decision that followed all of the steps necessary to get me a remedy in federal court if you win that ADR.
Okay, let me play devil's advocate. HRSA is in court right now simply for attempting to directly interpret the requirements of the statute. If a dispute arises or if a petition's filed in an ADR matter, will not the ADR panel face the same problem that HRSA is facing in these contract pharmacy lawsuits, in that there's no recourse to legislative rules? There's guidance that, for a variety of reasons has been under a shadow. Won't the ADR panel be called upon to make calls by direct recourse to what it thinks the statute means and requires, and what Congress intended when they passed the law 25 years ago?
The difference is that there'll be an administrative record. So one of the standards for review is substantial evidence. And so if HRSA creates a very robust review, I mean, no doubt about the ADR process works a lot better if we're talking about facts as opposed to law. But unlike the advisory opinion, unlike these letters that HRSA has sent out to various manufacturers, an actual so far that is an ADR process an ADR process would allow for both parties to submit briefs and HRSA to write presumably a very lengthy opinion that would then be the record. Because right now there's no record. Right now all we've got are, the 2010 contract pharmacy guidance, which triangulates to 1996 guidance, et cetera. It's not as if there's a very robust record that is the result of back and forth between various regulated parties. So there will be some differences, but there's no doubt that, in the background of all of this is the fact that Congress did not give HRSA the authority to write legislative rules other than in a few cases, such as the CMPs for egregiously not offering 340B pricing, et cetera. So it's true that they'll still be hamstrung, but not nearly as much.
If one of the several federal district judges, so far we've got one ruling that by Judge Stark in the AstraZeneca case that has vacated and set aside the December 2020 Office of General Counsel advisory opinion that that the statute obligates manufacturers to provide 340B pricing without regard to how the covered entity chooses to distribute its drugs, including contract pharmacy. And almost immediately thereupon, HHS withdrew that advisory opinion. So it's a dead letter. Right now, what's being litigated is the basis upon which HRSA issued its May 17th letters of finding to the six manufacturers. If a federal judge should rule that should rule against HRSA and HHS with respect to the legality of the May 17th letters, do you on the panel, how do you on the panel expect other drug manufacturers to react or respond? So far, there are 8 drug manufacturers that have announced restrictions. Were a federal judge to rule in favor of one of the drug manufacturers on one of these letters of findings, do you think that would propel more manufacturers to come up with their own restrictions or conditions on 340B pricing?
Depends on whether it's final action or not. I mean, because so much is in early stages, and what we're seeing is that there's going to have to be a lot more development, and so I mean, it could be 2 to 3 years before we see a court issue a final decision that's non-interlocutory, meaning just an interim part of the process. So we really could. It could be a while, and many manufacturers are going to probably want some sort of degree of finality, knowing that they're not going to be hit with CMPs before they move forward with their own programs. But so.
Okay. Well, I think that we've about wrapped up. So thank you for joining us here. I do believe that there'll be a slide coming up very soon that will give you information on how give you a little bit more information. There it is. Give you a little bit more information about what 340B report is and how you can subscribe. And for those of you who are participating today, for the next 2 weeks, you can subscribe for 25% off. So, in the meantime, if you wanted to find out a little bit more about whether we were a good fit for you, you can sign up for a free 15-day trial. Thank you to all of our panelists. This was very enjoyable, very informative. And does Rich or anyone else want to have any final words?
Yeah, let me just say as a final exit, we really want to thank Tom as well for partnering with us to do this. We work with Tom regularly. He'll send us a question and we'll appreciate maybe getting a behind the scenes look at something that's about to come out and vice versa. We, you know, when on the rare occasion that Victoria has a scoop on something, we may share it with Tom. So we really respect his work and have appreciated his insights over the years. So we just thank you, Tom, for taking the time to do this with us. It's a lot of fun.
Thank you for inviting me. It was a pleasure. I hope we can do it again.
Thank you. And thanks to everyone for attending.
Thanks, everyone.